Sri Rosmah, which came up for hearing today. The first application was in respect of an application for security for cause, right? And the second application was in respect of an appointment of a court expert to identify the 44 pieces of jewellery, all right? In respect of the appointment of the court expert, the court has allowed our application to appoint the court expert to verify the jewellery, all right? Of course, it is subject to the consent of Bank Negara, because Bank Negara says they are worried about the security threat because the jewelleries are kept in the vault. So if Bank Negara comes back and tells us that it's fine, you can go and inspect, so that inspection will take place, right? The second application was in respect of an application for security for cause. That application is for the plaintiff to put a certain amount of money into court before they proceed with the case. And the reason why the application was filed was because the plaintiff is a foreign company. It's a company based in Lebanon. It's not a company based in Malaysia. And the court has also allowed that application. The court has allowed, and the court has directed that the plaintiff pay a sum of 75,000 into court by the 11th of October. And if the plaintiff does not furnish that money by the 11th of October, then the plaintiff's case will be struck out by the court.
Sir, may I know on what basis the court allowed the two applications?
Right. As far as the application for expert, it is because, if you remember, the plaintiff said there was only 4 pieces of jewellery with the police. Right. And then subsequently, the chief of AMLA came out to invite the plaintiff to make an application to inspect the jewelleries. Right. And so the question now is whether there is 4 pieces or whether there is 44 pieces. We are not certain, right? And secondly, we then took the liberty to file the application to ask for a court-appointed expert, because it is our client's case. The 44 pieces are with the police, right? The government's position is there's only 1 piece. So you've got 4 pieces, you've got 44 pieces, you've got 1 piece. So how is the court going to run the case when there are 3 different versions as to how many jewelleries are there? So we say, in the interest of justice, our client should be allowed to get a court-appointed expert to verify whether the 44 pieces are there. So that is in that light that the expert evidence application was allowed by the court, right? As far as security for cause, like I've said, the plaintiff is a foreign company. It's a company based in Lebanon. And normally, whenever it's a foreign company, it is always the norm for the defendant to ask for a security for cause. And it was on that basis that the court had allowed the application for security for cause today.
There is another point I would like to add on. Ranjivan has already told you the rest. But one of the pertinent points we brought up today was also the fact that the government says that 12,009 pieces of jewelleries were actually seized during the seizure. But the AMLA court, in the forfeiture court, right, they have only listed down 11,900 pieces. So the question which we put before the court is, why is there this difference between the gazetted amount, which is only 11,000 pieces, and the amount which you have actually seized, which is 12,009 pieces? So where is the balance of a few hundred jewellery pieces? So in light of all these uncertainties, the court has agreed. The expert which we have nominated is an expert from India, called Dye Color, and we nominated them for this purpose. So we will be getting in touch with them. They are experienced jewelers, and they will come and do this examination of the jewellery, then to give a determination to court. All right.
So when the court allow expert to come in, she does not set any criteria for what the expert should be, a local
No, the criteria has been set by us because we made the application. So we have informed the court that this is the expert that we are proposing, and the court has accepted it because we have put in the profile of the expert from India, and that profile has not been challenged by the government or by the plaintiff. So that profile has been accepted.
Right?
Could you give us your name?
Yeah, sure.
So my client is suing.
There are many confusion number in this case. So by your side, what do you understand?
Well, the plaintiff's claim is for 44 pieces of jewellery worth roughly 60 million ringgit. And it is based on a consignment note So it's a sale by consignment. That's all. That's all the plaintiff's case is. Of course, the defendant has said, the first defendant has said that, the first defendant has said, hold this for me. The first defendant has said that it has been seized by the government. But that's not the plaintiff's issue. That is the issue between the first defendant and the government. The plaintiff only wants the 66 million back or the 44 pieces of jewellery back. So there were 3 applications before the court today. 3.
Today?
3. Not 2. The first application was for the expert witness to be appointed.
Okay.
The plaintiff did not has no position on that because that is between the first defendant and the government. That is between them. It doesn't concern us, so we did not take a position. And the court granted the order that the first defendant wanted to clarify the issue. Clarify the issue because there was a discrepancy. So the plaintiff was first invited to inspect the goods, rather inspect pictures. Plaintiff inspected photos of the goods.
It's not the
the goods are in Bank Negara.
Oh, okay.
It's in a safe in Bank Negara. The goods are in a safe in Bank Negara. 44, no, all. 12, I don't know. 11,000, 12,000, I do not know. 12,000 or 11,000 pieces are in the vault in Bank Negara. The plaintiff was invited by the police to inspect the goods based on a court order that was given by this court to show whether these 44 pieces were indeed in the possession of the police, because the government intervened. And so the plaintiff came, and the plaintiff was given a chance to look at pictures of the jewellery, and from the pictures only said, well, there are 4 pieces. And that was put in an affidavit and put in the court based on the pictures that the plaintiff saw. Then there was the head of, there was someone from the police who came out in the press and said, well, maybe the plaintiff did not see all the pieces, or maybe the plaintiff might be mistaken. So then the defendant put in the application to say that, then the police filed an affidavit here to say that only 1 piece was with the police. Okay, so 1 piece of the 44 that we're claiming, 1 piece of the 44.
Where's this?
So that is what they are asking. We are not concerned. We just want the money or the jewellery back. It doesn't matter to us who has seized the goods. It's a consignment sale. If you lose the jewellery, nothing to do with us. Pay us the money. So on that basis, we withdrew our application to amend because we do not know how many pieces are there, and we are going to, and we insisted on proceeding to trial. Trial means we go to court. My client gives evidence, defendant gives evidence, then the court decides. That court date has not changed,
Okay.
which is the date given 21st October.
Sir, may I know what was the original application you withdrew?
See, originally when we were told that there was only, originally when we found there was only 4, we wanted to amend to exclude the 4. But then when now we have a contradiction in terms, we're going to leave it as it is, and we're going to let the court decide after they have decided, but we're proceeding with the trial. We're going to leave that to the court to decide. So we are not going to go and amend because we do not know actually at this point in time what's there and what's not there. Alright, because we are only claiming 44 pieces, correct? So we withdrew the application to amend and proceed to trial. The second application was for the expert witness. Doesn't concern us. We stayed out of it. Court gave the order because we are not objecting. For whatever reason, court granted. Third application is an application for security for cost. If you remember, she asked for 500,000, or rather the first defendant asked for 500,000 security for cost, right? Of course, even though in the normal sense, if you're a foreign company and you have no assets, the court will give a reasonable sum. So we submitted that 500,000 is not a reasonable sum. So the court agreed with us that 500,000 is not a reasonable sum and said maybe a reasonable sum as security, 75,000. If we win, the 75,000 is returned back to us. If we lose, it goes to her. That's all. For legal fees, cost, party-to-party cost. Yes.
Yeah. So on the application on the expert, it was a submission between AG's chamber and the defendant.
Defendant, yes. It
Yeah.
did not concern.
What was the points raised by the AG side?
It was a security issue, simply because the this thing cost, it's a lot of money. 12,000 whatever pieces is a lot of money, and it cannot be moved around. It has to be in, so it's in the bank vault in Bank Negara, and it's not easy to go and get the ability. I mean, they don't. Yeah.
After consideration, the court only allow the expert to view the pictures.
To view the jewellery, but with the consent of Bank Negara.
Okay.
So that means the court order, please be very clear on this, the court order is for the expert to be allowed to view the actual jewellery as long as Bank Negara, the central bank, consents.
Okay.
That's all.
So it could be a stage where the Bank Negara can file a